Okay, folks, let's get started. In this video topic, we're going to talk about the unauthorized practice of law by non-lawyers. Let's jump in. Now, this is a state-by-state area of law, but each state, through some combination of statute and rule, will mark the boundaries of what we call the practice of law and who can do that and who can't. And so those sources of law govern four different areas. First of all, there are the non-lawyers who try to get inside that circle, who try to do the thing that we call the practice of law without a license. And then as we go to other parts of our discussion, we'll be talking about lawyers who collaborate with non-lawyers to provide legal services, team efforts between lawyers and non-lawyers. And then third, there are lawyers who collaborate with non-lawyers to provide not legal services, but ancillary or related non-legal services. And then finally, there's multi-jurisdictional practice. That is a lawyer who's licensed in jurisdiction A but is practicing over in jurisdiction B without a license. All four of those settings are relevant here, but for our purposes here, we're concentrating on situation 1. We'll save 2, 3, and 4 to talk about in other settings. So one of the main sources of law here is the ABA's model rule of professional responsibility 5.5. You can find it online at the ABA Center for Professional Responsibility. That's not just an extra thing that you might do. You need to get in the habit of going to those rules regularly. This has got to be a routine part of your preparation for our discussions. You could go to the ABA version of the rule, or you, even better, could pick out the state that is most relevant for you. Let's say that's North Carolina, but it could be anywhere. And go to the website for that bar. They will have their version of the rules posted. You need to get familiar with those rules. It just needs to become a routine habit for you to be going to those rules online. So 5.5 is the one that is relevant for our discussion here. Now, Rule 5.5 itself does not explicitly address non-lawyers. The whole body of the model rules are rules that apply to lawyers. But in the commentary, the official commentary to the model rules, it functions just like the official commentary to restatements. But the approved commentary to the model rules, comment 2 that's on your screen here, emphasizes that this varies from state to state. What counts as the practice of law, that thing that only lawyers can do, is defined by some combination of statute or perhaps case law in the given state. And in a high-minded fashion, the rules assure us that this is only to protect the public. And there is some public protection involved here, but we'll have to say, to be realistic, there's also some guild protection going on here, some self-protection by lawyers. We'll get to that more cynical take on it in a minute. Now, North Carolina, like many states, has a statute. In fact, it has a couple of statutes that define the practice of law. And I want you to notice from the language on the screen here just how broadly practice of law is defined. So we end up covering any effort to advise or give opinion upon the legal rights of any person, firm, or corporation, or to provide any legal service. And the statute also gives a few examples, but it's not restricted to those examples. Those are just illustrative. So a very broad coverage. Your casebook also gives an example, interestingly, from a district attorney's manual in Los Angeles, in California, that talks about providing legal advice and legal instrument and contact preparation, whether or not the subjects are involved in litigation. So typically you see quite broad definitions. The basic thing you're looking for is applying legal principles to the situation of a particular person. What I want you to notice is what's not covered. What's not covered is providing legal services for oneself. That is, this is all about offering the advice to someone else. So it's not the practice of law under these definitions if you're just doing the best you can for yourself, or if you're an employee for your own organization. This is giving advice to outsiders, outside yourself or outside your very own organization. Now, how does a non-lawyer get in trouble under these statutes? Who are the enforcers, and what's the enforcement structure? Well, in terms of who's out there policing it and watching, licensed lawyers are typically the people who bring to the attention of the enforcement authorities any non-lawyer who's thought to be practicing law. And why do they do this? Well, of course, they may be wanting to protect the public from poor advice and bad outcomes, but obviously there's also a sense of knocking competitors out of the game. So there's some mix of self-interested and public-regarding motives at work here. But there's a wide network of police officers out in the field, that is the licensed bar. The people who can practice law are trying to mind the gates and keep outside the people who are not supposed to practice law. Who's actually doing the enforcing once the police, that is the licensed lawyers, have found them? The state bar can petition courts for action against non-lawyers. Prosecutors, criminal prosecutors, can file charges, and in fact, under North Carolina statutes like Section 84-7, the district attorney even has the obligation to seek an injunction to stop UPL if any member of the bar files a petition and it's well founded. So in that situation, the prosecutor, quote, shall indict. It's a very unusual provision in North Carolina law. And it's a Class 1 misdemeanor to practice law in North Carolina without a license. So those are some examples of the enforcers out there. You've read an example of one of these enforcement actions. Marilyn Brumbaugh was a non-lawyer, not licensed. She was helping people fill out forms for do-it-yourself divorces, wills, bankruptcies. And she not only created the forms, typed the forms for people and helped them fill in the answers, but she advised her clients on which forms and that they would need, and she would explain the procedures that they would need to follow once they had the form in hand. She never claimed to be a lawyer. She just said, I'm providing secretarial services. The Florida bar was the source of the complaint here, and they petitioned, it's interesting in procedural terms, they petitioned directly to the Florida Supreme Court for an injunction, and the Supreme Court appointed a referee who received the evidence and made the findings of fact and conclusions of law. So now the Supreme Court is hearing an appeal from the findings of that referee, and the court did hold that Ms. Brumbaugh could legally sell these forms, and she could fill in the blanks as a typist, but she couldn't provide any legal advice to her customers. So here's where the Florida Supreme Court draws the line between things that are the practice of law and things that are not. They say, okay, you can sell legal forms, and you can type in the blanks for the legal forms for a customer. You could even publish books that advise people about how to complete legal forms. But that's all you can do. You can't go further than that and advise individual customers in person about how to complete legal forms. So we see both here in Florida, you also have read about some examples from New York and other jurisdictions. The key difference here is individualization. If you're in a setting where you are applying legal principles to the individual situation of a client, that crosses the line into practicing law. And that's what you need a license to do. And how do these rules apply to legal software? Are they more like the individualization that happens in a conference between a lawyer and a client sitting in an office? Or are they more like somebody selling a book and then the customer opening up the book and reading the book? It obviously falls somewhere in the middle. There is some individualization involved. The software is designed to do exactly that. Tell us about your situation, and we'll now tell you which of these legal areas will be relevant for you. So in that sense, it looks an awful lot like what Ms. Brumbaugh was doing. You saw an example of both a judicial opinion in this area on Quicken software dealing with family law. And then you saw the reaction of the Texas legislature after that decision, redefining the unauthorized practice of law to allow this kind of legal software to go forward. So in general, there has been a broadening of the availability of this kind of software. It typically does not fall under the definition of unauthorized practice of law, or at least that's the direction that we are heading. Now, these UPL statutes are already relevant to your life. You may be aware of this or you may not, but the whole world is conspiring to ask you to engage in the unauthorized practice of law. It's probably already happened to you. You've been at a party or somewhere, and a friend who knows you're a law student comes up and says, "Hey, I'm having trouble with my landlord. He's not fixing the shower. I finally did it myself. I just fixed the shower. It cost me $100, and so I plan to deduct $100 from my rent payment next time to cover the cost of the materials. You think I'll be okay?" Has this happened to you yet? Now, here's what I want you to do. Stop the recording now and say out loud how you would reply to your friend. And then start the tape again, and we'll talk about various answers that one might give. But really now, stop the recording. All right, do you have your own reply in mind? Okay, now let's talk through some potential answers. Here's potential answer number 1. You might say this: "Well, my friend, based on what I learned in property class, you're not going to be okay. This sounds like trouble to me." Here's potential answer number 2. "You know, friend, you get what you pay for, and my advice here is free, so it's not worth very much. But my quick impression is that you're not going to be okay." Here's potential answer number 3. "Well, friend, I can't comment on your particular situation because I don't know nearly enough of the details. All I know is that, this area of tenant withholding of rent based on the condition of the premises is generally more friendly to landlords than to tenants, but really the answer in your situation would depend on the particulars, and I don't know those, and if I were to give you more advice about this, it would be the unauthorized practice of law. So that you may want to talk to a licensed lawyer about that." Here's potential answer number 4. "Gosh, what an interesting question. I'm a law student, but I'm not a lawyer. I'm not licensed. And believe it or not, I can't answer your question even here in this setting until I pass the bar. It's a crazy thing, but that's the way the bar works. So save up those questions. I want to hear about all of them once I'm licensed to practice law. But for now, I'd better steer clear of trying to answer that because that gets me in trouble with the bar authorities." Now, as between these 4 answers, I think answers 1 and 2 are pretty clearly going to be trouble. Now, you may or may not ever be actually brought up for charges in front of the bar, but those pretty clearly cross the line into the practice of law. Answer 3, I think, walks right up to the line. You're probably okay. It's not the safest answer, but it's okay and it's socially acceptable. Answer number 4 is socially a little bit more awkward, but really the most proper answer, which is just to say I can't go there. But at any rate, my suggestion to you is practice. This situation is coming up, will continue to come up. You need to think ahead of time about what your answer will be, how you will handle these questions when they arise. So on we go to other contexts for the unauthorized practice of law. We'll talk soon.